recently the case that was cited about the missing witness rule, so I can't say specifically what's in it, but I am willing to bet that the missing witness rule does not apply when there's been a valid assertion of a privilege or other immunity for keeping the witness out of court. So, for example, if they tried to subpoena the defendant's lawyer and the defendant said, wait, I have attorney-client privilege, you can't subpoena him, they're not going to be able to get an adverse inference from that. And that's critical because, as I've gone through multiple times, and we keep going back and forth on this, they keep representing that there was a blanket defiance and there was no explanation and there was no legal basis for what the president was doing. And it's just not true. There were letters back and forth. I put them up on the screen. There were specific immunities asserted. There were specific legal deficiencies in the subpoenas that were sent. And this is important because if you're going to impeach the President of the United States, turning square corners and proceeding by the law matters. And for the House managers to come here and say, it was blanket defiance, it was unprecedented, that you have to draw an adverse inference against them because they didn't respond to any of our document subpoenas. All of the document subpoenas were issued without authorization. Maybe they disagree with us, but they can't just say, we provided no rationale and you have to draw an adverse inference. There was a specific legal rationale provided. And they didn't try to engage in the accommodation process, and they didn't try to go to court. And now, yes, it's true. Our position is that when they go to the court, Article 3 courts don't have jurisdiction over that. Their position is Article 3 courts do have jurisdiction over that. They believe that they can get a court order to require us to comply with a valid subpoena. But they never tried to establish in court that their subpoenas were valid. We have an assertion of a legal deficiency on one side. They think it's different. They don't want to go to court to get it resolved. We have the assertion of absolute immunity from congressional compulsion for senior advisors to the president. It's been asserted by virtually every president since Nixon. They try to say, oh, it's preposterous, it's irrelevant, we don't have to worry about that. Every president since Nixon, virtually, has asserted that. It's only been addressed by 2 district courts, trial-level courts. The first one rejected it, and its decision was stayed by the appellate court, which means the appellate court thought, probably you got it wrong, or at a minimum, it's a really difficult question, we're not sure about that. And the second district court decision is being litigated right now. They're litigating it. And when they say that when Charlie Kupperman went to court, they were trying to do something reasonable to say, oh, well, we don't want to litigate this with you. You should just agree to be bound by the McGahn decision. What's the saying, every litigant gets his day in court? Why shouldn't Charlie Kupperman get to have his counsel argue that issue on his behalf? That's what he wanted. He didn't want to say, I'm going to trust it to the other people litigating the other case. I've got my case. I want to make the arguments. But they wouldn't have that, so they mooted out the case. They withdrew the subpoena to moot out the case because they didn't want to go to the hearing in front of Judge Leon on December 10th. They've also pointed out, as if it's some outrage, that documents have been more readily produced under FOIA than in response to their subpoenas. But what that actually shows is that when you turn square corners and follow the law and make a request to the administration that follows the law, the administration follows the law and responds. And that's right. The documents were produced. Information came out. But they didn't get it because they issued invalid subpoenas and they didn't try to do anything to establish the validity of their subpoenas. If you're going to be sloppy and issue invalid subpoenas, you're not going to get a response. But if some private litigant follows FOIA and submits a FOIA request, they get a response. So to act like the Trump administration has done some blanket denial of everything simply isn't accurate, and there's no basis for any adverse inference because there's a specific privilege or basis for every reason not to produce something. Thank you.
Thank you, counsel. Mr. Chief Justice.